Hi, my name is Erica Magalhães, and I am participating in the New York University Media Law course. As part of the work of Module 3, we were asked to make a video with a presentation of our Greywork proposal, and mine is a language learning app. So, in my is a language learning app available for smartphones and tablets that could be downloaded at Play Store, Apple Store, and so on. It will have a monthly fee charged automatically on the user's linked account, but also a free version of it. This app will use some music, short movies, and cartoons for language teaching, and one of the features will be the karaoke module. In this part of the lesson, the student must sing along with the music, and the app will evaluate the right pronouns. Student will be able to record his singing performance to check on where are the wrong pronunciations to fix it later. Also, this app will allow the student to dub cartoons characters with the same purpose of the karaoke module. When the student reaches a good grade, the right pronunciation, it will be possible to find some secret phases with other music and cartoons. User will be encouraged to buy new songs. Billboard songs must be paid to unlock, but again, to unlock, it will be necessary to reach a minimum rate. This will make the student to study and practice more. But there are some important points to know. Music available to sing or cartoons to dub won't be the whole music or cartoon. It will be only partial, so this will impact on fair use about amount and substantiality copied and how much you need to copy to be an infringement. Another point is that the app will be profitable, but the profit on it is for educational purpose. Reinforcing the monetization of the app is directly linked to the educational purpose, not to the use of songs in karaoke, as this is just a module of the app. To produce the app, I will try to use crowdfunding or Kickstarter at first. There are some cases that could be some legal precedents that confirms that my project could be considered a gray area work, such as Marcus versus Rowley, where it weighed against allowing fair use. In the case, they said that to qualify for educational exemption, the excerpt must adhere to brevity. While there are various criteria, the portion used must be a minor part of the total work and intended for a maximum teaching effectiveness. Court ruled in favor of the plaintiff in this case and decided that fair use doctrine did not apply because any of the reasons pointed on the defense supported a finding on fair use. And another case regarding education and copyright, it was Encyclopedia Britannica Educational Corporation versus Crooks, a school district acting as governing body, videotaped television broadcast for use by the school. They got into an agreement and they could use the content with the condition of destroying the tapes within a 7-day period. So this could be considered a gray work because despite of having the purpose and character of an education app, it's not clear about the amount and substantiality copied because it will be used only partial songs. So as we've seen in our classes, it could be considered a fair use under 17 USC 107. Also, there are dispositions about the use without infringement of copyright in the Teach Act that allows the usage of copyrighted work to teach without infringing any law. It isn't clear because it's not possible to know if the app will be supported by an educator or an educational institute, but it isn't clearly illegal because it has some of the four factors of fair use that we've seen, and also the profit on the app. It's not about the music use, but for educational purposes. As I am a foreign student from Brazil, I want to make a comparison between Brazilian and American copyright law. Brazilian copyright law was created in 1998 after a long 20 years legislative process, and between 1998 and 2018, copyright in Brazil suffered significant changes, and there's a lot of debate questioning this law. Brazilian copyright law was considered to be less permissive regarding enabling access to culture, and it was listed in 2012 by Consumers International, a non-profit organization focused on consumer protection, as the fifth worst copyright in the world about the rights of those who consume intellectual works. In the same list, USA is considered the country with the fifth better copyright law. Consumers International access issues such as access to culture, exceptions and limitations for use of works, such as allowing copies for educational purposes, private use or preservation, and adapting the law to new technologies. Brazil received the worst scores in the scope and duration of copyright and the freedom of access and private education and libraries. Online access got an intermediate grade. In Brazil, a work is protected for 70 years after author's death. In addition, the law does not allow copies to be made nor for private use. The example is recurrent. Literally, in Brazil, the Brazil law does not even allow music to be copied from iPod computer, for example. Brazil's copyright law limited non-profit private reproduction through Article 46, Item 2, that says it's allowed the reproduction in a single copy of small sections for private use of the copyist as long as it is made by him with no intention of profit. But now I want to analyze my peer response to my project that follows. Okay, here we can see that my peer analyzed the user's point of view and what can be produced by this user. And I appreciate the considerations pointed on this review because, as I said, it has the user point of view and what can be produced by this user. My peer has brought the voice recordings as the issue on an eventual copyright infringement that wouldn't happen because of the terms and conditions of the app itself that would be covered under the copyright law. But the main point on why this is a great work is the educational purpose. The music will be used as part of the learning. After revising my project, I decided that songs will be partially played at the karaoke feature. And one of the factors considered on fair use is the amount and substantiality of copied work. In my app, a language learning app, not a karaoke app, one of the features will be the sing-along to check on the pronounce of the learning users. The music of karaoke won't be the whole song, but only parts of it. The karaoke feature will be used strictly to educational purpose, and that leads us to the Teach Act. So here we have Teach Act and fair use, and for example, for a dramatic musical work such as sung, danced, recited, played, etc., Teach Act allows significantly more online distribution of copied material than does fair use, but face-to-face classroom display of rented material is unlimited. The Teach Act also allows the online presentation of reasonable and limited portions of digital copies of music performances up to the amount allowed in a face-to-face class. And it is in this statement that I'm convinced that my language learning app won't be considered an infringement to the copyright law. But the Teach Act requires copies to be presented using technical format that inhibit in students copying of presented resources. So when the student, the app user, download his singing for self-evaluate, it may have a doubt on some copyright infringement. Um, So under the fair use, there's a strong limit of the amount of musical performances of which may be copied as opposed just to display it. There's a limit that may be digitally copied and incorporated into a multimedia program produced by an educator or student for educational purpose, but attribution and credit must be given. And this is something to be considered when developing my app. There are some cases and current discussion on the amount used on um, using music to teach, especially on music teaching, actually. And Ricky Beato is a musician and an educator, and he puts it, how are you supposed to educate without examples of music to bring it to life? And how can he bring an example from a track demonstrating a scale or a certain feel without infringing a copyrighted song? That is education, and that is totally fair use. But he got this copyright claim of YouTube on a song played quietly in his headphones for just a second. And the most interesting part of the story is that his video wasn't demonetized until it hit 1 million views. So could be the profit he made on the video the main issue for getting this claim? Why nothing happened before? This is an open question I make here. Another similar case to this gray area is about a music director, Elia Haja. I'm sorry for the wrong pronunciation of his name. That made karaoke app Smule remove songs from their database by not seeking prior permission for using his tunes. And Smule is an app, a karaoke app that allows users to use the app for free, but if users want unlimited access to song or want to sing solo, duet, or in a group, they are asked to pay a monthly fee. In this specific case, the music director said he was only against people who were using the songs commercially without permission and not against the fans using the songs. So once again, we can talk about the fair use, the purpose and character of the use, and also the effect of the use upon the potential market for. Um, well, that was my great work proposal, and I appreciate all of you for watching. Thank you.